Welcome to the deep dive. We're continuing our series trying to make patent law a bit more accessible.
Yeah, we're working through the Manual of Patent Examining Procedure, the MPEP.
One section at a time. The idea is to give you clear summaries, really focusing on the core principles.
Think of it less like reading the manual cover to cover and more like a guided tour of the important bits.
Exactly. And today, we're jumping into a really interesting part of Chapter 2100, which covers patentability.
Specifically, Section 2156.
Right, Section 2156. This one deals with joint research agreements, particularly under the America Invents Act, the AIA.
It tackles a potentially tricky situation for collaborators.
How so?
Well, think about it. When partners are researching together, they share information, right? Disclosures happen.
Sure.
Normally, some of those disclosures could become prior art under the AIA's Section 102A2.
Meaning they could block a later patent?
Potentially, yes. But Section 2156 explains how certain disclosures might get an exception if they happen under a qualifying joint research agreement.
Ah, okay. So it's about making sure collaboration doesn't accidentally shoot itself in the foot, patent-wise.
That's a good way to put it. It helps innovation partners avoid unintentionally blocking each other.
Okay, let's dig into that. What's the basic problem that Section 2156 is designed to solve?
The core issue comes from the standard definition of prior art, especially under AIA 35 U.S.C. Section 102A2.
Right.
If you have, say, two different companies working together, Company A and Company B, without a special rule, if Company A publishes something related to their joint work, that publication could technically be used as prior art against a later invention claimed by Company B, even if they were working towards the same goal.
Because the law sees them as separate entities.
Exactly. For prior art purposes, they're usually treated distinctly.
That seems like it could really discourage open sharing and a collaboration. Do you have an example?
Sure. Let's use the biotech example. Imagine two firms, maybe Innovate Bio and Chem Solutions, working together on a new vaccine. Let's say Innovate Bio files a patent application disclosing a specific compound they developed as part of the project. Later, Chem Solutions invents a new formulation that uses that very compound, maybe making it more effective or stable.
Right.
Under standard rules, Innovate Bio's earlier filing disclosing the compound could potentially block Chem Solutions from getting a patent on their formulation. It's considered prior art.
Wow. Even though they were partners, that sounds counterintuitive if you want people to work together.
It definitely can be, and that's precisely the problem the AIA tries to fix with the joint research agreement exception.
So what is the fix? What does the AIA say in 35 U.S.C. Section 102C?
Okay, Section 102C lays out three very specific conditions. If you meet all three, that disclosure might not count as prior art.
All three. What's the first one?
First, the subject matter that was disclosed, like the compound in our example and the invention being claimed later, the formulation must have been developed by or, on behalf of parties to a joint research agreement.
Okay, a formal agreement.
Yes, and crucially, that agreement had to be in effect on or before the effective filing date of the claimed invention. The timing matters.
Got it. Agreement in place before the filing date. What's condition number 2?
Second, the invention itself, the formulation, must have resulted from activities that were within the scope of that joint research agreement.
Ah, so it can't be some random side project. It has to be part of what they agreed to collaborate on.
Precisely. It has to stem from the work covered by the agreement.
Makes sense. And the third condition?
The third one is about transparency in the patent application. The application claiming the invention, the formulation in our example, must disclose or be amended to disclose the names of all the parties to that joint research agreement.
So you have to name names, basically. Tell the patent office who was involved in the agreement.
Exactly. You need the timely agreement, the invention has to be within its scope, and you have to list the partners in the filing.
And if you check all three boxes...
If you check all three, then that earlier disclosure by one partner, Innovate Bio's filing, generally can't be used as 102 prior art against the other partner's later invention.
So why is this exception so important? What's the underlying policy goal?
It really just acknowledges the reality of modern R&D. So much innovation happens collaboratively now, right? Between universities, companies, different research groups.
Sure.
This rule aims to facilitate that. It prevents the normal prior art rules from inadvertently penalizing partners who are trying to innovate together.
It smooths the path for teamwork.
Yeah, you could say that. It stops partners from being afraid to share results internally or file initial applications for fear it might block their collaborators down the line.
So, Back to the biotech example.
Right. With a proper joint research agreement in place and meeting those three conditions, Innovate Bio's disclosure of the compound likely wouldn't prevent Chem Solutions from patenting their formulation using it.
That makes a huge difference. Now, you mentioned this is part of the AIA. Was there something similar before? I feel like I've heard of this concept previously.
You're probably thinking of the CREATE Act. That was the Cooperative Research and Technology Enhancement Act of 2004.
Ah, yes. Create.
The AIA provision we're discussing, 102C, definitely builds on the foundation laid by the CREATE Act, but it expanded it quite a bit.
Expanded how? What are the key differences between the AIA approach and the older CREATE Act?
Well, there are a couple of big ones. First, the scope of what it protects against. The AIA exception under 102C can overcome prior art for rejections based on both anticipation under 102A2 and obviousness.
Both, okay? And create.
The CREATE Act was narrower. It generally only applied to overcoming obviousness rejections based on prior art that qualified under the old pre-AIA 102E, F, or G. So the AIA offers broader protection.
That seems like a significant upgrade. What else changed?
The timing reference point is different too. The AIA keys everything to the effective filing date of the claimed invention. The joint research agreement must be in effect by that date.
Okay, the filing date.
The CREATE Act, on the other hand, was keyed to the date the invention was made.
Ah, the invention date. That sounds harder to pin down sometimes.
It could be. Shifting to the effective filing date under the AIA makes it, a bit more concrete and aligns better with the overall first inventor to file system. It's a clearer line in the sand.
So the AIA version is broader and uses a clearer time marker.
Got it.
Now, for someone actually filing a patent, an applicant, if they want to use this exception, what do they practically need to do?
Good question. It's not automatic. MPEP 2156 is clear on this. The applicant has to affirmatively invoke the exception.
How?
They need to submit a specific statement to the USPTO. The statement basically asserts that the conditions of 35 U.S.C. Section 102C, those three conditions we discussed, are met.
So just having the agreement isn't enough. You have to tell the examiner you're relying on it and meet the criteria.
Exactly. And there are formalities. The statement needs to be presented separately. It can't just be buried in the remarks section.
A separate document.
Well, presented separately, clearly identifiable, and it needs to be properly signed, of course.
Okay. And what about naming the parties if they weren't in the original application?
Right. If the application as filed didn't name all the parties to the joint research agreement, you'll need to amend the application specification to add them.
And does that cost anything?
It might. Amending the application for that purpose might require paying a processing fee. You'd need to check the current fee schedule.
So there are definite procedural steps.
Yeah.
Make the statement, make sure it's separate and signed, amend if needed to name parties, and potentially pay a fee.
Correct. The Patent Office needs that explicit confirmation that the requirements are satisfied.
This has been incredibly helpful. It really clarifies how collaborations can navigate potential prior art issues. Any closing thoughts on this section?
I think the main takeaway is that this joint research agreement exception under 102C is a vital tool for collaborative innovation. Understanding it and using it correctly means companies, universities, researchers, they can work together more effectively without inadvertently undermining each other's IP.
It really highlights the value of formalizing collaborations up front, doesn't it?
Absolutely. Having that written agreement, defining the scope, and being ready to meet the USPTO's requirements, it's all part of protecting the valuable inventions that come out of teamwork. It helps ensure that collaboration actually accelerates innovation, which is the whole point.
Couldn't agree more. And just our standard reminder, this discussion is based on MPEP Section 2156. It's for educational purposes, definitely not legal advice.
Right. And we should also mention this summary was prepared using AI tools like ChatGPT and Notebook LM, so there could be errors. Always go to the official source.
Yes, please consult the official MPEP itself, or talk to a qualified instructor or a registered patent practitioner for any specific legal guidance.
And we also want to give a special thank you to Mike Shepard. He's the creative director behind this whole educational series, and we really appreciate his work in making it possible.
Absolutely. So, a final thought for you, our listener. Thinking about your own work or industry, how could a clearer understanding and the maybe better use of joint research agreements change the way collaboration happens? Could it unlock more innovation? Something to think about. Thanks for joining us for this deep dive.